Welcome to the Court of Appeals, the morning session. Your panel today is all from the western section, and we're delighted to be here, as we always are, to come to Nashville. To my left, Judge Carmel McGee from Savannah. To my right, Judge Kenny Armstrong from Memphis, and I'm Judge Arnold Golden from Memphis. Just to refresh everyone of how we operate, you know, we have a timer here. Each side's entitled to 15 minutes. And the timer will let you know when your time is running out. The appellant is entitled to reserve up to 5 minutes for rebuttal if you choose to do so. So you can let us know on the front end whether or not you would like to reserve any time, the appellant, up to 5 minutes for rebuttal. Of course, the appellee does not get rebuttal. Is there anything else we need to address? You may call the first case.
Jim Hysen versus T.A. Smythe.
Good morning, Your Honors. Drew Justice for the appellant. It's Thomas Smythe, and I'll reserve 4 minutes.
You may proceed.
The arbitrator in this case exceeded his powers because he expelled Smythe and excluded him from the wind-up as a wrongfully dissociated partner on a ground that was never agreed to by the parties to be submitted for arbitration. What they agreed to was they agreed to arbitrate basically 3 issues, or whether to expel Smythe on 3 possible grounds. They did not agree to, and Hysen never even asked for, Mr. Smythe never agreed to, and the court never ordered any arbitration over whether to expel Mr. Smythe on a 4th ground. And that 4th ground, which the arbitrator wound up expelling him based on, not only did no one request it, but it was a ground that doesn't even exist under the law. And I say that not to argue that, you know, we should get reversal here on the basis of an error of law by the arbitrator, because I know that that's not possible. It's just relevant, just sort of for background, because if that were a 4th possible ground to expel someone, then Hysen would have requested it. Smythe very well might have agreed to it, and the court very well might have ordered it, but it isn't, and they didn't. The reason why Mr. Smythe's agreement or non-agreement to this 4th ground matters is because the partnership agreement itself simply did not bestow any general powers to an arbitrator to adjudicate legal claims, legal questions. Any objective reading of the partnership agreement, I submit, shows that they did not broadly agree to arbitrate legal questions. What they agreed to arbitrate was, they specifically said all business decisions have to be unanimous, and then they said if we're not unanimous, then we're gonna get a 3rd party to give his vote and break the tie. And they don't even really use the word arbitrate in the body of the contract. They do use, I think they use the word arbitration in the one of the subheadings in the contract, but there's a section toward the end of the contract where it specifically says that these subheadings they're to be ignored when interpreting the contract. And so if we ignore those as we're supposed to, the word arbitrate never even appears in their partnership agreement.
At the trial court level, did you object to arbitration, counsel?
We did not object to arbitration of those 3 issues that Mr. Hysen was requesting to arbitrate. And so I submit that our failure to object to those 3 issues does not go further and say, well, any other possible question can also be arbitrated.
How did that come about?
How did
the 4th question come about?
It came about basically due to the arbitrator just misunderstanding one of the statutes. There's basically 4 partnership statutes that are relevant to this appeal. One of them is 61-1-601, and that's the one that lays out all the different grounds on which a partner can be expelled, including the 3 that Mr. Hysen was seeking to argue. Then there's 61-1-602, and this is the one that the arbitrator sort of went off on a tangent on, and that's the one that basically says if you leave the partnership for any reason before the contract expressly says you're supposed to, whether you're expelled or whether you just abandon it or whatever, then you're a wrongly dissociated partner. And the arbitrator got confused and thought that that meant any time you breach the contract in any express way, you're therefore wrongly dissociated. But he's just, I submit, just dramatically misinterpreted that statute. And then
Let's assume we were to determine, as you suggest, that the fourth question shouldn't have been raised. Does that change anything?
It does change things because under D&E Construction Company, which is, I think, the main case I cited, the main case that talks about it, but it just says if an arbitrator goes beyond the scope of the arbitration agreement, then he exceeds his powers. And that's also one of the statutes that we cited in our motion to vacate the award. I think in my reply brief, I cited it as the right statute. It's 213, section 213. In my opening brief, I somehow got it mixed up as 312. But under subsection, I think it's A4 of that, it says that if the arbitrator exceeds his powers, that's a ground for vacating the award. Mr. Hysen has said that we should look at the other section, I think it's A5, where it talks about if you, like the complete absence of a partnership agreement. And I would just submit that section doesn't really apply here because we did, in essence, agree to some form of arbitration over those three issues. We just didn't agree to the more expansive powers that the arbitrator ultimately took upon himself. So by exceeding his powers and coming up with this fourth ground that no one asked for, no one agreed to, and that the court didn't order, that's our argument for why the arbitration was wrong. And just to be clear, that under the three arguments that Mr. Hysen did ask for and that we did agree to arbitrate, we were supposed to look at whether Mr. Smythe has engaged in wrongful conduct that adversely and materially affected the partnership, and the arbitrator did not find any adverse effect at all, certainly not material, because he said that it was just a possible adverse effect. And then number two, we were supposed to look at whether Mr. Smythe had willfully and persistently committed a breach of the partnership agreement. And here the arbitrator did find that he breached the agreement, but there was no finding that it was willful or persistent. And then number three, whether Mr. Smythe has engaged in conduct that makes it not reasonably practical to carry on the partnership. The arbitrator did, to some extent, find this criterion, but he didn't expel Mr. Smythe on that basis. And basically he just said that the partnership had broken down. He didn't even really expressly fault Mr. Smythe for it, I submit. But he was listing these criteria which use the exact same language from a different statute, which is 61-1801. And he laid out all the different criteria in 61-1815. And one of them is that statement, which basically says, he was basically saying the partnership is broken down. It's not reasonably practical for them to work together anymore. So therefore, I'm going to dissociate. I'm going to dissolve the partnership. But anyway, he didn't rule that Mr. Smythe, engaged in specific conduct that deserved being expelled. So he didn't.
Yeah, let me ask you before you use all your time. Why don't you address the issue of whether or not you feel it was timely?
On the issue of whether it was timely, it was timely. Rule of Appellate Procedure 4 says you get 30 days from the entry of judgment. Rule of Civil Procedure 58 says that entry of judgment is determined by the date on which the face of the judgment is marked as filed for entry. And then here we had the clerk and master specifically testify that that date was May 15th. He said that when the judge initially just submits the order before it's approved by the clerk, that the clerk can look at the document, they can look at the PDF and review it, and at that point there's no file stamp on it. So it's not marked on its face as filed for entry. But he said that once they approve it, then it gets shifted over to a separate system that I think he called TNCIS, whereas at that point it is marked on its face as filed for entry and it has the file stamp on the PDF itself. trial judge, in sort of ruling to the contrary, he based his rule entirely on local rule 4, where it says that under their rules, any filing, an order, or just any kind of filing is deemed filed or considered filed on the day when it's first submitted. But the problem with that ruling is it doesn't really address the question we've got to address, which is not when something is deemed filed or whether it's considered filed, but when it's entered, and specifically when the face of it is marked as filed.
And the date of filing on that order was what date again?
The date when it was marked as filed for entry was May 17th, which is exactly 30 days prior to the notice of.
What was the date that order was signed by the trial judge?
It was the day before, which was May 16th.
My copy says electronically filed on May 16th.
Yeah. And so why does it matter about when the clerk enters it on the minute book? Why isn't it controlled by the date that the judge files it?
Under the rule, the governing rule is Rule of Civil Procedure 58, which says that, in essence, it doesn't matter when the judge turns it in. What matters is when the.
What section of Rule 58 do you rely on for that argument?
I think it's
What's
only
the
like.
language in 58 that says that? Because I don't read it that way.
It specifically says that entry is effective. Entry of a judgment is effective. I don't have it right in front of me to read to you, but it says entry of a judgment is effective when it is marked on its face as filed for entry. And then it lists some other requirements, namely that it's got to have a certificate of service and things like that. But so on this case, the clerk specifically testified that it did not become marked on its face as filed for entry until he approved it, which is also when that notification email goes out, which was a little after 8 a.m. on May 17th.
So
Are you saying at the hearing, the clerk of the court said that the effective filing date was the 17th of May and not the 16th?
He didn't give, to whatever extent he gave a legal opinion on that, he did not say that, but he did testify to the fact of when it was marked on its face with that file stamp. And that was when he approved it, which was on May 17th at 8:05-ish a.m.
And when you say when he approved it, are you talking about an entry on the minute book, which is different from the date that a trial judge signs an order?
I don't think the word, I don't honestly know whether I don't think the word minute book was ever used, but what I questioned him about was when it was marked on its face. And so when they put the file stamp on it that says filed on the PDF, as opposed to just having it on some separate Excel sheet. Their computer makes a note of when the judge initially turned it in, and then the point is, even if the clerk gets to it a day or two later, they've got a rule, and then marks it on its face a day or two later, they've got a rule that says it's going to be backdated, and I'm saying that that's inconsistent with Rule 58, or to whatever extent whether it's consistent or not, the true filing, the true date of entry is when it's marked on its face.
So let me ask you one other question then. So according to your argument, if I'm following what you're wanting us to basically accept here, on page 1 of this order, you've got a stamp at the top that says electronically filed May 16 at 4:17 p.m. So you're saying we should disregard that?
I basically am saying that Your Honor should disregard that, and that an opinion saying that we should disregard it is needed so that this error won't continue. I had one case where I filed a lawsuit a month ago, and the clerk didn't even approve it and get it turned in until 2 days later. So, there are a lot of times when these things get delayed. With a lawsuit or a complaint or a motion, the delay doesn't really matter, but with an order, according to Rule 58, it does matter, and they should make it.
If you accept the electronically filed date on the lawsuit that you filed 2 days and wasn't handled by the clerk for 2 days later, that you'd be saved.
And what I'm saying is a different rule applies for complaints, motions, because you just look at Rule of Civil Procedure 5 for deciding when something is filed, but when you're looking at when an order is entered, that's under Rule 58, and that's a different rule. And so that's my position. Thank you all.
All right, thank you. You'll have your rebuttal time. We'll hear from the appellate.
I'm Bill O'Brien. I represent Jim Hysen. And for the reasons that we set out in our brief and what we're going to talk about today, the court should dismiss the appeal as untimely. But if the court does proceed to deal with the issues on the merits, the trial court's order confirming the arbitration award should be affirmed. The denial of the motion to vacate should be affirmed. And the other orders that are being appealed should be affirmed by this court. We felt obligated to raise the timing issue because without a timely filing of a notice of appeal, this court does not have jurisdiction to resolve the issues on the merits. We can't confer jurisdiction on the court by consent. And so we felt like it was at least our obligation to raise the timing issue with the court. I think the court has picked up on the fact that the electronic filing rulings that were reviewed by the trial court in a Rule of Procedure 24 hearing, the court determined that the electronic filing rules operated to affect the acceptance of the judgment on May 16th. That was the official file date on the order that went out in the courtesy email the next day. There's no issue that all of the litigants received an email from the clerk that said official file stamp May 16th, and that was on the morning of May 17th. We think the unfortunate circumstance was that the appellant got to June 16th, like a lot of human beings, assumed 30 days, that would be the last day. Unfortunately, there's 31 days in May. So then at that point in time, the appellant filed a notice of appeal, but didn't recite the official file stamp date in the notice of appeal, but basically created a new file date of May the 17th. So if you looked at the Court of Appeals, you'd see a recital that the order was entered on May 17th. That's not entered anywhere. One other point that we would make and suggest to the court in determining this issue is there should be some certainty in terms of when an order is final, and so that the parties can rely and comply with those orders. The argument asserted by the appellant in this case, even his last example, creates a lot of uncertainty. If my client has been ordered to disperse $10 million in a case, and the 30 days runs, and there's no notice of appeal, there's no notice of stay, can my client proceed to rely on that order, not knowing that 2 days later, one of the litigants is going to argue that the file stamp was backdated and there was a timely appeal and there's a motion for stay? Uncertainty is created by the suggested interpretation by the appellant in this case. If the court does proceed to decide the issues on the merits, we respectfully submit that the order entered May 16, 2022 should be affirmed. That order confirmed the arbitration award that was entered on January 17, 2022, and the only ground asserted by the appellant in this case for reversal is that the arbitrator exceeded his powers. The fact that Jim Kay, the arbitrator, did not exceed his powers is established by several things. First, we disagree. There was a broad, unlimited arbitration provision in the partnership agreement. It provided that any disputes between the business partners, my client and the appellant, any dispute would be resolved by a binding decision of a third party, and that provision was in the partnership agreement. That establishes that it was not outside the power of the arbitrator, but more so, the appellant did not object to the request, to the application for an order referring this matter to arbitration. And as the court will see, in the application, there is a letter that lists all of the relief that my client was seeking through the arbitration provision. And in that, my client specifically requested the expulsion of the appellant from the partnership, the dissolution of the partnership, and that he be the partner appointed to wind it up. So to say that the issue upon which the arbitrator ruled was not subject to the agreement of the parties is simply not correct. It was stated, it was presented to the court, and then the court ordered and delegated that issue to the arbitrator to resolve. The application was specifically referenced.
Was there any objection to that?
Pardon?
Was there any objection to what the court ordered the
No.
arbitrator to resolve?
No,
No objection was raised in the trial court?
no. And then, more so, the third thing is, then it was referred to Mr. K as the arbitrator, and one of the first things Mr. K did was say, all right, you state your issues that you want presented, Mr. Hysen. You state your issues, Mr. Smythe. The parties, following the arbitrator's procedure, listed the issues that they wanted tried. And in fact, the relief that my client has sought was the exact same relief that the appellant sought in arbitration. He sought the expulsion of my client. He sought the dissolution of the partnership. He sought appointment of himself as the partner authorized to wind up the partnership affairs. So in fact, it was the flip side of the relief that was requested by my client in the arbitration. He asked for it, and then he proceeded to, I was going to say a trial, but to the hearing in the arbitration, trying those issues.
Was there any objection made to that issue being tried at the arbitration?
No. And so, Your Honor, from your questions, I think one thing we would note is we think that the statute 29.5.213A5 is dispositive in terms of, that's the statute that sets out the grounds for vacatur. And in that statute, it says they could argue that there was no arbitration agreement and that the issue was not, if the issue was not adversely determined in proceedings under 29.5.203, well, it was. The judge did, in fact, in his order, find that there was a binding arbitration agreement, and the party did not participate in the arbitration hearing without raising the objection. And that's clear. The party did participate without raising the objection. We respectfully submit, Your Honor, that in this case involving a 50-50 partnership that had two provisions in the partnership agreement that we think really are determinative or helpful to the resolution of the case. One is the partnership said that no decision could be made unilaterally. They had to have 100% consent on every decision that was made in the partnership. The court can see where that leads because they disagreed. It also had the broad provision in terms of resolving the business disputes would be resolved by binding third-party decision. The parties couldn't get along. In fact, the appellant in this case went out and signed a contract to sell the partnership property to a third party, signed it in his own name, and said he was going to sell the partnership property. The transferee, the purchaser, got that contract and said, hey, we think we can enforce it, ran down and recorded it, and placed the effect of recording a contract, claimed contract rights in the property, and the partnership became gridlocked. That's what's led to the demand for arbitration, because the partnership could not develop its property given the antagonistic actions by the parties. In the arbitration application, Mr. Hysen, and I am reading specifically from the demand, demands the arbitration of the expulsion of Mr. Smythe as a partner of Inanna GP pursuant to TCA 61-1-6015 as a result of the facts that Mr. Smythe has engaged in wrongful conduct that has adversely and materially affected the partnership business. Mr. Smythe has willfully and persistently committed a breach of the partnership agreement or duty owed to the partnership or Mr. Hysen under TCA 61-1-1-404, and or Mr. Smythe has engaged in conduct relating to the partnership business which makes it not unreasonably practicable to carry on the business in partnership with Mr. Hysen. The arbitrator had an evidentiary hearing in January of 2022, and based on the evidence that was adduced, and again, that had both sides, because the evidence being submitted by my client that he was most qualified to wind up the affairs of the partnership was countered by the evidence proffered by the appellant, who said, no, he's not a good person to wind up this project, let me do it. And the arbitrator heard that evidence and made a decision. And as a result of that decision, he found that this partnership could not reasonably carry on the business for which it was formed, given the provision that both sides had to agree on every decision, and given Mr. Smythe's participation in the project. There was no assertion at any time in the arbitration provision that the arbitrator had no authority to decide the issue of expulsion, dissolution, and appointment of the partner to wind up the affairs of the partnership. Mr. Smythe, in his brief, and we did cite this in our brief, he admits the dysfunctionality of the partnership. In his view, it was just simply who should be the one appointed to wind up the affairs. Smythe moved as a result of the ruling. He moved for vacatur of the hearing. The trial court conducted a hearing simultaneously with the motion to confirm the arbitration award, and decided that the arbitration award should be confirmed, the motion to vacate should be denied. That's when the May 16th, 2022 order was entered. And then the notice of appeal was filed on June 16th, 2022. Your Honor, we've already addressed the issue of consent, and the delegation of the issues specifically include the issue that the appellant now contends is the, quote, fourth, close quote, issue. That issue is encompassed when you delegate to the arbitrator. The decision is, one, do you expel a partner? Two, do you dissolve the partnership? And three, do you appoint one of the two partners to wind up the affairs of the partnership? So the matter of which the appellant complains is the matter that he agreed to litigate and lost on. The court knows from the well-established jurisprudence that an error of law is not sufficient, or even an error of fact is not sufficient to overturn the arbitration award. And in essence, what we hear today is a fanciful, conflated argument that fourth ground, what is really being said is that the arbitrator miscited the statute. There's another section of the same statute which says that if you are expelled, you're deemed to be a wrongfully disassociated partner, and you're not eligible to continue in the management of the partnership affairs after dissolution. So when you boil it down, when you distill it down, the argument is the arbitrator got it wrong. He cited the wrong statute. I just have a little bit of time left, and I'll briefly comment. There was an issue that was raised in a second appeal about the trial court's order limiting what Mr. Smythe could do. In the arbitration award, it was determined that the partnership, not Mr. Smythe, owned the real property and the development rights. After the order was confirmed, after the order confirming the arbitration award was entered, was final, was appealed, but was not stayed, Mr. Smythe went out and basically claimed to be the owner of the property and talked to the town of Fairview and really said, don't work with Mr. Hysen because he really doesn't own the development rights. That ran directly contrary to the unstayed final order of the court. We asked the trial court to impose some sanctions, saying stop him from doing this because we can't do what the arbitration award is, which is develop the property.
Would the trial court have had authority at that point to do what you asked in that the case was on appeal, counsel?
We asked for sanctions or contempt, and the trial court said, I'm not giving that to you. And what the trial court said is, but that doesn't end it, and basically looked at Mr. Smythe's direction and said, stop doing what you're doing.
Did the court enter an order to that effect?
Yes.
Did the court have jurisdiction to enter that order at that time?
I think it did, because I think the court always has the authority to enforce a final unstayed order. That's my time. I'd be happy to answer any questions if the
Thank you very much.
court has any. Thank you.
Justice, you have 4 minutes.
To very briefly address that last issue, the court did not have any jurisdiction to issue an injunction because the case had been over for more than 30 days, and so the court had lost jurisdiction. In addition to that, the court just didn't hear any evidence. It was admitted that res judicata didn't apply. There was no trial. And then to top it all off, I still submit that ordering someone not to talk to a court or to an arbitrator or to a city official, that violates the First Amendment, and it's a prior restraint on speech. So that most recent order was unlawful. To just briefly touch back on this issue about the timeliness of the appeal, opposing counsel has said that we would create uncertainty if we don't just go by whatever file stamp the clerk chooses to put on something. I submit the uncertainty is created by the clerk doing the wrong thing, putting the wrong date on there. And I'm not saying that it's a nefarious thing. I'm just saying the clerk basically hasn't studied the rules and hasn't fully thought through how this local rule is inconsistent with State Rule 58. And so we've got the clerk doing the wrong thing, and then we've got, even when I file a statement of the proceedings, we've got the trial judge refusing to correct the clerk.
You're not saying that the electronic file date that's on this order is incorrect?
I'm saying it's not a correct reflection of when the judgment was entered. And again, the key word for a judgment is not when it's filed, not when it's turned in, it's when it's entered. And it's entered, entry of a judgment is effective when a judgment or order containing one of the following is marked on the face by the clerk as filed for entry. So it has to be stamped. It's the moment it's file stamped, that's when it becomes effective. And if I file stamp it from 5 days ago, that doesn't mean it was actually entered 5 days ago. That just means I put the wrong file stamp on it. And so here he put the file stamp from 1 day in the past, and that was wrong. And the reason it's...
Let me ask you, do you dispute that the trial judge signed it on the 16th?
No.
And then e-filed it, and the date on the e-filing is the 16th?
No, what I'm saying is that the judge basically turned it in on the 16th. If this were a paper document, it'd be like he signs it on the 16th, he sets it on the clerk's desk on the 16th. For whatever reason, the clerk is too busy, doesn't get around to file stamping it till the next morning. And so when it's file stamped, that's when it becomes entered.
But he e-filed it, is that correct? This is not a situation where he signs the order and then walks it over to the clerk's office.
That's right. I mean, it was e-filed, but the same principles and the same rules should apply.
And the e-filing shows the date is May 16th.
Right.
And that's also the date that the judge signed
And
it.
what I'm saying is this court should explain to the trial court that that's incorrect so that the trial court will get with Tibera or whatever their company is and start implementing a date of entry on orders, not just a file stamp that's backdated.
Let me ask you one of those questions because you're running out of time. Do you disagree with Mr. Brady that you made no objection either at the trial court level or at the arbitration level to the issues that were being heard by the arbitrator?
We did object in our motion to vacate after the award. And so the first time we object... No, before.
Did you object when the trial court set out what the issues were to be before the arbitrator to hear, or did you object prior to the hearing of the arbitrator to hear those issues? Did you do that? That's a yes or no question.
No, we didn't. But those three issues I'm not complaining about. I'm not objecting to those.
Well, there was a fourth issue apparently, right?
The fourth issue was not invented or created until the arbitrator ruled. And so the point is, we objected as soon as that was out there. We said, that's wrong, you don't have the power to do that. And we did object as soon as that was created. But before then, we didn't object because no one had created that as an issue. Anyway, we do submit that the arbitrator exceeded his powers. I do ask that the judgment be reversed. Thank you all.
Thank you very much, counsel. We will ponder this case and render opinion as soon as possible. We're going to take a brief recess before we hear the next case. We'll reconvene.